I'm Cynthia Rowland, and this is episode 74 of EO Radio Show. This week, I'm delighted to have as my guest my partner, Holly Sutton, a member of our top-notch employment law practice. Holly's my go-to person for complicated employment issues for our nonprofit and private client practice. Our clients often come to us with a request to help them think about employment practices and compliance questions. Holly will update us on what's new in 2024 in California and federal laws that employers need to think about. And she'll also give us some tips on how to think about risk management and employment law compliance now that remote work is here to stay. Even small nonprofit organization clients now often need to navigate employment laws in many jurisdictions. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. I'm so happy today to be joined by Holly Sutton. Holly is the chair of Farella's employment practice. She guides businesses, comp committees, and boards in managing the critical employment matters they face, with an eye toward both practical solutions and risk management. In her busy practice, she counsels clients on the design and implementation of employment policies and practices to minimize the risk of employment litigation. She also ensures compliance with applicable laws. Specific areas in which Holly advises her clients include personnel policies, wage and hour laws, EEO compliance, hiring and termination practices, harassment and discrimination investigations, non-compete clauses, conflict of interest policies, and trade secret matters. Holly is often called on by clients to help them navigate particularly high-risk scenarios and challenging situations, including reductions in force, realignment of workforces, mergers, acquisitions, and divestitures of businesses. An essential part of her role as a trusted advisor on employment matters is ensuring that her clients are kept abreast of the latest developments in employment law, an ever-changing field. She's a frequent speaker, author, panelist, and media source, and in addition to advising on the current state of the law, she frequently counsels on upcoming changes and trends that will affect her clients' business, strategy, and workforce. Thanks for joining me, Holly. I'm so glad you could be here to talk about all of this today.
Oh, it's really my pleasure. Very excited to be part of this initiative, Cynthia.
As I was describing all the things that you do, I'm like, wow, that's a huge area to cover. So tell us a little bit about yourself so that the listeners can appreciate the depth of your commitment to the field. What drew you to the law and to employment law in particular?
Well, it's interesting. I've been practicing in the area of employment law almost exclusively for a couple of decades now. And, when I first got into employment law, it wasn't as robust a practice as it is now in 2024 and as we expect it to be in the foreseeable future. So there were many more practitioners who were what I would call dabbling in employment law and other areas of the law. And that's how I started as well. But very quickly got focused in part because of the growing needs in the area. And I will say this is one area, particularly when giving advice and partnering with my employer clients, where having experience is such a tremendous advantage. We have lots of really impressive junior attorneys in our practice, which right now we're up to, I think there are about 17 lawyers in our employment practice group. And they're just fantastic. But when it comes to giving advice and guiding employers, it is one area where I think having the experience and having seen so many different scenarios, many of which often come out of left field, that really can best prepare someone to guide employers going forward. So that's part of why I continue to really enjoy the area and feel like I'm adding value in my practice.
Yeah, I've certainly thrown you a few curveballs with some of these nonprofit clients in the past. And I do totally appreciate the fact that this is not an area to dabble in. first of all, for me anyway, when I look at the bodies of law that are relevant, it's just an enormous number of laws that can touch on employment practices, and they're all changing, and there's 50 states and even more jurisdictions. So talk a little bit about that. When employer is thinking about employment law compliance, what laws do they need to think about?
Excellent question. And I will say post-pandemic, we're seeing that become an even greater challenge for employers because more and more employers are embracing hybrid work, or fully remote work, which often means they're now employing employees in other states. So whereas, maybe 5 years ago, all of their employees were in one jurisdiction, now we're seeing more and more of our clients are having to rise to the challenge of managing a workforce in multiple jurisdictions. And as you mentioned, in any given town, you're already required to keep abreast of both your applicable state laws and then the overriding federal laws. And the general rule is the employer has to know both because you have to comply with both. And to the extent they're inconsistent, you have to follow the law that's most beneficial to the employee. And then in many of our larger metropolitan areas, we are now seeing greater activism at the city level. So we've got local ordinances that are granting benefits and particularly leaves and other protections to employees. So we've added that triple layer. And then, of course, if you've got a workforce that's scattered around, you're expected to know both, what's happening in San Francisco and the state of California, as well as, maybe off in Austin, Texas as well. It's a real challenge. And I think with the nonprofit employers, like many of my smaller and mid-sized employers, it's very difficult to staff a full-time HR department that can monitor and stay abreast of all of these changes. It's an area where the legislature and the agencies are almost in a constant state of change. Every year, as you know, Cynthia, we do a sort of roundup of the changes coming. It seems to be almost every year the list gets longer. It's a real challenge for smaller employers, and nonprofits are included, of course, in that group.
What I see are kind of maybe three categories. There's the big nonprofits that have a lot of employees and a lot of staff. They're like any other business in large part. And then there's the well-endowed, relatively small staff private foundation that may have a lot of resources. So risk management really matters, as a deep pocket, but not very many employees, or maybe all the workers are trying to be, they've been traditionally treat them as independent contractors, or they're part-time and they may be scattered throughout the country. So they have kind of unique set of issues. And then there's the very small nonprofits they raise their money just in time to keep the operations going. And they're just continual scramble to do their good work without a ton of resources. So each of those has kind of a little bit different profile.
That's right. And what I see more and more is our clients that don't have a robust in-house legal team. They are more and more incorporating into their operations an advice attorney, essentially on retainer. And that's important because, as everyone listening to this podcast can appreciate, employment issues rarely give you a lot of advance notice. They tend to come up. They're very urgent. A lot of the time, they're going to pop up about 3:00 on a Friday afternoon. That is not a time to be trying to line up employment counsel. Many employers will have someone like me, a regular part of their resources. And instead of trying to track and anticipate changes, they just know that when something's going on that's out of the ordinary, they have someone they can call. So, for example, if they've got somebody who wants to go on a leave, or they've got someone they need to let go, who they're having performance issues with, they've found that the most efficient model is just to be able to rely on outside counsel to then guide them to those specific fact situations as they arise. And then also, ideally, somebody who will remind them when laws are changing and they need to update their handbooks and their policies, et cetera. And it's, for many employers, that's a more efficient model than trying to manage all of that inside or in-house. And I'm glad you mentioned the independent contractor question. Would this be a good time to speak to that a little bit?
Let's talk about that. And then I want to circle back to employee handbooks and offer letters. But anyway, yes, let's talk about, I think that's a great way to start. Then we'll go to those other two things and then we'll talk about what's new. How about that?
Defined pattern that I see, as you mentioned, with nonprofits who tend to rely more on independent contractors than some of my other clients for a variety of reasons, I think. And that is an area right now where we're seeing a lot of activity. California just passed some pretty major legislation not too long ago that really restricted the ability to classify a worker as an independent contractor. And we're still seeing that play out in the field and in the employment climate. And then at the national level, there's actually an initiative right now they just, I think, recently finalized some regs to, again, narrow those definitions of who can be an independent contractor. So that's an area where we're seeing a lot of activity. And unfortunately, if an employer has misclassified an independent contractor who really should be classified as an employee and entitled to those benefits, there can be some fairly serious exposure and liability. And so that's an area that is certainly worthy of attention for those clients out there that are kind of setting their priorities in terms of what things they need to be thinking about with their workforce.
Yeah. And I think that leads right into upfront risk management, thinking about engaging your specialist outside employment law counsel. And then I want to leave enough time to talk about what's new in employment law, the specific new things that have developed. The way it often comes to me is if I'm lucky enough to be setting up a new organization and able to set in motion current and high quality employee handbook or personnel handbook, that's often the first time we have a conversation with a nonprofit employer about all these laws and how they'll have to keep track of it. At the same time, there's usually some thought given to the offer letters and onboarding their initial employees. Can you talk a little bit about how to manage that at the outset in the most efficient way? I mean, does the new client just call you and say, hey, tell me what I need to do? Or are there some key questions that frame setting in motion their best practices for their employees and how to think about the engaging and sending out offer letters? And then once you've had that conversation, then you or a similarly situated employment lawyer becomes the person who's available and at least has a copy of the personnel handbook on that Friday afternoon when urgent action is needed. I put a whole lot in there, but I think you get the gist of where I'm trying to go with that.
Yeah, I try to be as practical as possible when it comes to, say, a new nonprofit starting up with a limited legal budget. I do counsel my clients that to the extent you can invest upfront, you can save yourself so many resources by getting things right from the beginning, much less expensive than trying to go back later and fix things, whether that's hiring someone without nice, clear employment agreement in place that specifies either that they're at will or that they're under a certain term expectation. And unfortunately, trying to do those things on an informal basis will often end up costing more in the end in terms of cleaning things up. In particular, what we see are employers that just want to pay all of their employees on a salaried basis. And in some states, that's easier to do, but in many states, there are restrictions on who can be paid salaried without any overtime. And often we do see misclassifications, which end up being quite challenging to unwind down the road. So when clients are at the very beginning and you have this nice, clean, blank slate is when I think it makes the most sense to try to tackle some of those more challenging questions and save yourself a little bit of trouble down the road. And of course, handbooks are so important. And sometimes we will say, okay, let's just get the bare bones minimum in place so that you're at least, legally compliant. And then we can tackle the other stuff, additional time off and leaves and some of the nice bells and whistles. Those don't necessarily have to be there from day one, but it's so important to have those basic requirements met at the beginning when possible.
And that is a great segue into what I really wanted to talk about today, which is what's new in employment laws for 2024. Because you can write a brilliant handbook and have it perfect for the date the organization is created. And then lo and behold, nobody looks at it until 5 years later when something bad has happened. And so, what is new for 2024? Let's touch on some of those highlights and give some direction for further resources on what's new today.
Yeah, absolutely. Many states are, and at the national level, we are seeing restrictions on what employers can deem confidential and what restrictions they can impose on what employees can say and who they can talk to about the workplace. So one important flag for everybody listening to this podcast is that if you have an old template for a severance agreement, if you've let someone go, eliminated a position, and you've offered them a severance in exchange for their release, there's a very good chance that release, if it hasn't been updated in the last year or so, will be non-compliant under some fairly significant developments at the federal level. And a number of states are also making those changes and prohibiting certain restrictions that were fairly common in separation agreements, and specifically confidentiality agreements and non-disparagement agreements. So we're seeing a lot of movement in those areas. Leaves and paid leaves are another area where there's a lot going on. The states are becoming more active in requiring paid sick leave. For example, in California, the minimum number of paid sick hours that have to be granted to employees, both full and part-time, often trips people up, has increased. So many California employers who were compliant last year are no longer going to be compliant if they haven't taken a look at that sick leave policy. And we're seeing that as a trend in many states, not just in California. Lots of other leave laws being rolled out, which again, is why I mentioned earlier, if somebody needs to take time off, that's a good juncture to think maybe we should consult with counsel on this. By way of example, there's 2 new leaves in California, the reproductive event leave, which is new, and bereavement leave. Some of these leaves are not necessarily paid leaves, but they have to be provided if the employee seeks them. Those are some areas where we're seeing some pretty significant developments.
As we wrap up a little bit here, what has Farella recently done in terms of educational seminars? Can you talk a little bit about the projects and educational materials that are out there and available for our listeners?
Absolutely. We hosted an employment law update symposium in January to address some of the more substantive legal developments in California and at the federal level. And we had a really nice turnout because many employers are aware that they need to try to stay abreast of these issues. So we did the symposium in the office and then have actually tagged it on our website for anyone who wants to come back and view the video of the symposium.
And I think that's on the YouTube channel as well, or it will be at some point. So, and those are in segments, right? There's several different specific panels.
That's right. We did a number of series. We had three different panels that tackled a number of different subjects, including the severance changes I mentioned earlier, big changes going on in non-compete, the area of non-competes, not something that I see too many nonprofits imposing on their workers, but an area where there's definitely been additional restrictions. And we had a whole section on various types of leave laws. We are also seeing new requirements around workplace violence prevention, to name just a few.
Those are all such important and current topics. Do you have any closing thoughts? Anything that you would really want the nonprofit employer to keep in mind as they think about how to manage the best practices and think about avoiding risk in this area? Any parting thoughts on that we haven't talked about yet?
Sure. I'm just a real believer, and part of what I love about my advisory work is the whole concept of an ounce of prevention, right? When I speak to employers, I really encourage them to try to reach out for that advice early on, when the facts are still developing and when the employer still has the ability to adjust the outcome. Once an employee's been terminated or a complaint's been made and the lawsuit's been filed, the cost tends to go way up and it gets harder, to solve that issue. So I'm just a proponent of trying to reach out and bring in your outside counsel earlier rather than later when you can.
That's great advice. Well, thank you so much, Holly. I think this is going to be really useful to a lot of our listeners, and we'll put in the show notes links to these employment webinars and other materials. But anyway, thank you so much, Holly. I really, really appreciate this.
My pleasure. Thanks, Cynthia.
So that's all for this episode. Be sure to check out the show notes for links to more resources. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martell. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.